Good afternoon. I hope that you are with us. Zoe McGrath and I are going to give you a short whistle-stop tour through findings of fact as we know them. Have they disappeared? Or something quite like that. Zoe is a former solicitor with over 20 years of experience, specialising in both public and private law, children matters, the whole range of private and public law matters. She is a member of Chambers with me at 42 Bedford Row. We want to tell you a little bit about some of the things that have happened recently. We will endeavour to speak and chat between ourselves for about 20 minutes, and then we'll leave about 10 minutes for questions. We've already had a few questions which have been sent in advance, so we will answer those if nobody else has any questions. So as far as the extremes are concerned in findings of fact, we are all very familiar with the extremes. We have the long and unfocused ones, which have been happening for quite a long time, in my view. We also have those of the more recent variety, where you go into court and you try and persuade a judge to give you a decent length, and you're given your 5-day maximum without any experts. And we also have, I guess, the third, where the judge categorically refuses to allow you any findings of fact. We both know, Zoe and I, that you're coming from different ends of the spectrum. I suspect you are. Some people will be very keen to have findings of fact. Some people won't be keen to findings of fact. The emphasis, for understandable, pragmatic, financial reasons, are that there should be much shorter, sharper hearings, fewer hearings, shorter in length, fewer witnesses. We would like to discuss with you, and we're lucky that Sharon Badgew from Chambers has been in this case throughout, the January 2023 case, which is HW, Care Proceedings, Further Finding of Fact 2023. We'll stick that reference in the pages which are going to go on the website. It's a long case with a long history. It's been to the Court of Appeal, to the Supreme Court with our very own Damien Woodward-Carlton and Katie Phillips, as well as Sharon. And in January this year, Lord Justice Baker, of course, my very favourite judge, gave a judgment in this case. Let me tell you briefly the facts. We refer to it not just because Sharon Badgew's in it, because that's a good reason in itself, but we refer to it because it's a lovely little summary of the law that you need to apply. Let me tell you, before Zoe tells you about the principles, what the facts were. So it's been to the Court of Appeal, it's been to the Supreme Court. It goes back to first instance, having been considered by the Supreme Court. And it looks like welfare is about to happen. There's loads of children, loads of parents. There's a directions hearing. On the eve of the directions hearing, a 12-year-old child makes allegations against one of the fathers who's very much in the frame to have the care of the children jointly. Directions have already been made. The local authority realise or think they need a finding of fact hearing in order to make a final resolution, find out what the care plan is going to be. Kids are with the mother, that's fine. The father wants to go in there too. He's living separately. And there's really quite deeply unpleasant allegations of sex, historic allegations of sex made against this chap. Sharon, on behalf of the local authority, applies to have a further finding of fact hearing. I suspect because the court is very much aware it's already been to the Court of Appeal, it's already been to the Supreme Court, wants to get on with it. There is a 1-hour hearing at which this application is made. The judge doesn't see the ABEs of the 12-year-old girl who makes the allegations. He doesn't apparently have particular good position statements or skeleton arguments, although I can't believe that. He's not referred to the authorities in the matter, and he goes along and says there will not be a finding of fact. The local authority appeal that decision, and the Court of Appeal, Baker LJ, reminds us what the law is. Zoe, and what does he remind us?
Well, he reminds us of the principles and the basic principles of Oxfordshire County Council, which are still the principles that the court are going to be considering. And as we've already indicated, HW, Sharon Batchu's case, is a really lovely case to look at because it really does go through those basic principles again. So we start with the Oxfordshire County Council case. And that's what any judge still should be looking at when deciding whether or not to hold a fact-finding hearing. It was commented on in that case. There's been lots of comment in a number of cases about those principles from Oxfordshire, but it's still what we should be citing and what should go into a position statement in preparation of any application if you are seeking a fact-finding hearing. So just as a short reminder, in the Oxfordshire case, it says the authorities make it plain that amongst other factors, the following are likely to be relevant and need to be borne in mind before deciding whether or not to conduct a particular fact-finding exercise. And they are A, the interests of the child, brackets, most significantly, which are relevant but not paramount, the interests of the child. B, the time that the investigation will take. C, the likely cost to public funds. D, the evidential result. E, the necessity or otherwise of the investigations. F, the relevance of the potential result of the investigation to future care plans for the child. G, the impact of any fact-finding process upon the other parties. H, the prospects of a fair trial on the issue. I, the justice of the case. And in improving this statement in re HDH, Peter Jackson, amongst others, agreed it's unnecessary, to cite any other authority, although the approach outlined in Oxfordshire predates the incorporation of the overriding objective into the family procedure rules and the 26-week requirement. He says, in my judgment, it remains valid when read alongside the statutory framework. It helps judges to reach well-reasoned decisions, and counsel appearing in the present appeals were content to frame their submissions by reference to it. Many of the factors identified in Oxfordshire overlap with each other, and the weight to be given to them will vary from case to case. Clearly, the necessity or otherwise of the investigation will always be a key issue, particularly in current circumstances. Every fact-finding hearing must produce something of importance for the welfare decision. And that's really crucial, isn't it, Tina?
Yeah, absolutely crucial. Baker J's judgments are absolutely delicious, so are Peter Jackson's. But that must be the crux, mustn't it, Zoe? Because although your skeleton argument is really important when you have a really short hearing like this, an hour's hearing, and the judge was LJ was very defensive about this judge and was clearly reluctant to allow the appeal because he was saying this poor chap has only had an hour. He didn't see all the evidence, but it was a case management decision, and he should have allowed the finding of fact because it brings in this case an important decision without which the welfare decision could not be made. In fact, one of the interesting things about the Sharon's case, HW, is that the respondent to the appeal, one of the parents' counsel, said in the Court of Appeal, I concede that the care plan cannot be finalised unless this information is known. And Baker LJ referred to that several times. So when Zoe just said to us, every fact finding must produce something of importance for the welfare. I mean, if you can answer that question, yes, it does, or it needs to, then you're going to get your finding of fact. If you answer it negatively, actually, we don't need this for the welfare, then you're not going to get your finding of fact. I mean, it's really pretty straightforward, isn't it, Zoe? It's really pretty simple from that point of view.
It is, and that's where preparation is going to be really important for any hearing looking at this, that you have thought about, can I answer that question? And how am I going to persuade the judge that the answer is what I want it to be? And as you say, if you prepared that, you've got a good position statement or skeleton argument, then you're going to be on your way to getting the fact-finding hearing that you need.
But as we know, these are case management decisions. And Baker J actually says later on in the judgment that this decision as to whether there should be a finding of fact is one of the most difficult decisions for a circuit judge, for any judge to make, because it's do or die, isn't it? It's absolutely key to whether or not you can make a final welfare determination. And as we all know, case management decisions are difficult to appeal. They are often robustly and probably too quickly made because the courts are really busy. And I'm afraid to say, in my view, whether they're right or wrong is very often contingent upon the caliber of the judge. We all know fantastic judges. We all know judges who most often get it right. They're really busy. They are dealing with lots of cases every day, and I have a great deal of sympathy when they get it wrong. But we all know, as barristers and solicitors, if a case management decision is wrong, we are so unlikely to be able to appeal it. And by the time we've appealed it, time will have gone by, and we've wasted time, and we've wasted our 26 weeks. And the overriding objective, which is being rammed down our throats, probably quite rightly, but I say that a bit grudgingly, the overriding objective, paragraph 1.4 of the Family Procedure Rules, is there and up front and central because of the resource issues. And it's worth looking at that again, because the overriding objective came after the Oxfordshire case. And obviously, actually, I had to look up the overriding objective, because in our heads, we all know what it is, but in practice, we don't. So it includes dealing with the case justly, so far as practicable, ensuring it's dealt with expeditiously and fairly, dealing with the case which is proportionate to the nature, importance, and complexity of the issues, ensuring the parties are on an equal footing, and saving expense. So those really are human rights fairness, pragmatic, and expense issues, and are finally allocating its appropriate share of court resources, taking into account the need of other cases, competing cases. So we are in this perfect storm so far as limited resources. We all want the findings to be determined so we can carry out welfare, or actually, would it be quite nice to find out whether little Johnny was buggered by his dad or not? Do we need to find it out? It depends on the magnitude, I think, of the harm, and it also depends on the circumstances of each and every case. I think really the best thing about HW, not least that Sharon and Damien and Katie were in it, that's a good thing obviously in itself, but it is that perfect summary case. It's really short in a Baker LJ way. The judgment's really short, and you can cut and paste for your skeleton argument. One of the interesting things, though, I think you've already touched upon this, is it emphasizes preparation, doesn't it?
It does, yes. One of the criticisms, as we've already spoken about, was that the preparation for the case, the position statements, didn't say to the judge, this is what you need to be thinking about, this is the case law. And that's something that was, I think, Baker J was concerned about, and certainly commented on throughout.
There's a nice quote which I've written down, and I'm going to read it because he uses the phrase magnetic factors, and I think it emphasizes what you and I have just been discussing. And he says, in this case, an analysis conducted by reference to the principles in the case law should have identified that the magnetic factors in deciding whether or not to allow further fact-finding hearing were the necessity or otherwise of the investigation and the relevance of potential results of the investigation to the future care plans of the children. So if you remember that phrase, magnetic factors, the sticking factor is, do I need the answer to this question for the future care plan of the children? Back to the same point we've just made. If you can answer that yes, you're going to get your finding of fact or be able to appeal it. If you answer that no, you're not going to get your finding of fact. So I think that brings us on to Re-G Post-Mortem Report Delays 2022, which I think there's been a lot of talk about, but it is relevant. I think, in my view, it's probably the most significant change, although it's quite narrow, because obviously it just refers to pertains to dead babies, post-mortem cases. But I think it has caused us all, certainly me, when I first heard about Re-G, I thought, how on earth can you do a dead baby case without the post-mortem? But Zoe, give us a brief summary of Re-G.
Well, this is what REG says. So it's REG Child Post-Mortem Report Delays 2022 EWFC. And I should say at this point, there will be some reference materials that people can access alongside this video, and they should be available from Monday with this video. And this case concerns difficulties caused in family proceedings arising from the delay in completion of post-mortem reports following the death of a child. Such cases reach the family court where there is a surviving sibling and where uncertainty about the cause of death might give cause for concern for the surviving child also being at risk of harm. And this was interesting because this was a judgment delivered by the President of Family Division, Sir Andrew McFarlane, but it's not, there was an agreement in the proceedings. So this wasn't a judgment as such, and the President has made clear that this judgment is not an authority in any way, and that decisions in other cases are for the trial judge in each case to resolve. That being said, the President does give quite strong steer to judges about the style of case management that they're expected to adopt in dealing with cases of suspected child homicide. So the problem that the judge was addressing in this is the extreme delay, which is regularly encountered in the preparation of post-mortem reports from pathologists following the suspicious death of a child, which can be considerable. I think this case, a simplified illustration of the potential impact upon the surviving siblings and their families is provided when we look at G and how the process and the timings of that worked out. So the death of G's brother occurred in 2021 when G was around 21 months old. The likely date of any decision post-fact-finding would probably be summer 2023 or even later, by when he would be 3.5. Alongside that, in G's case, as in others, the police investigation had also stalled because of an outstanding post-mortem report. So the President's blunt statement following this was, the timescales that are now regularly encountered in care proceedings following the death of a child are wholly outside those required by Parliament, and they are plainly contrary to the welfare of any surviving sibling who is the subject of such proceedings. The judgment analyses the causes of the delays in post-mortem reports, which relate primarily to the structural and systemic issues described in a note prepared by the Home Office to assist the court. One particular area of difficulty is the severe shortages of osteoarticular pathology experts. So what this judgment then goes on to say is we can't be waiting this long for the final post-mortem reports, and we need to be looking at another way. How can we be dealing with this? And I think the answer in short is Part 25 applications. So he says the judgment suggests two strands of potential solutions to be used in combination where appropriate: the instruction of an alternative post-mortem expert, or B, use of evidence gathered prior to death. So where possible, as we would in other fact-finding scenarios where there isn't the death of a child, we're looking at evidence leading to the precipitating event, the court should be looking at that evidence rather than waiting for the post-mortem report, or looking at Part 25 applications of other experts. And what he basically says is the only situation where you will have to wait for the post-mortem report is where this incident that caused the death of the child was out of the blue, essentially. There wasn't any other evidence leading up to the death that can be relied upon. Generally, Tina, is that your understanding of that?
Yeah. And I think, I mean, sudden death and suffocation is another one. So if you really only have the death and there's no other history and there's no head injury or there's no fractures, then one would have to wait for the post-mortem reports. I'm reminded by one of the attendees that we should be talking about allegations. I'm going to come back to REG, but quite right to remind me that allegations, we have a binary system here. So allegations, unless there is a finding of fact, are on a binary basis. Nothing's happened, nothing's proven, nothing's happened. And that's really important in terms of our case planning, our welfare planning. Coming back to REG, because although not an authority, Sir Andrew McFarlane reiterated the guidance in HDH and Oxfordshire and said, where findings of fact are concerned, we are still going to be looking at those. It's still a way to be looking at findings of fact and whether they should happen or not. And bearing in mind, again, the emphasis of the overriding objective, we need to do justice efficiently. I feel a bit dim, actually, Zoe, because until Re-G, it had never occurred to me that this was an alternative way of dealing with a dead baby case. I have been doing these cases for a really long time. And we all just, I just took for granted that dead baby, you're going to wait 12 months for your post-mortem. Professor Mangum particularly, and that's no criticism of him, we don't have enough experts who do his type of work. And then we'll start doing the other evidence gathering broadly, or we'll try and do the part 25 pediatrician and radiology alongside of. But really your starting point for your trial date and your experts meeting was a year down the road. And I think it's a brilliant idea. I wish I'd had it, that actually we look at the baby as if the baby were alive. And we have the radiologist, and we have the ophthalmologist, and we have the neuroradiologist, or the neurosurgeon if we want to. And you look at all those things, because we don't need to determine how the baby died. The fact that the baby has been injured and suffered harm is the issue. So ex post facto, I do feel a bit dim for not having thought of that was a way forward. But I also think had I turned up at court and said, oh, for goodness sake, judge, we don't need to have this post-mortem stuff, we can just jump straight in there and we can have the live baby experts and deal with it that way. I wonder, would they have laughed me out of court? Because the fact it has come from Andrew McFarlane and others, the worthy people, the clever people, perhaps that made them think, and also the crisis. We were in crisis, weren't we? Because all these cases were just backing up, and these poor grieving families were sitting there waiting for a solution, and the children were sitting in care, just really, really waiting. So I think
this is guidance that is welcome, and you think it's going to have a really positive impact.
And I've got 2 or 3 cases. I've got 2 cases definitely at the moment, which are dealing with the cases this way. Bizarrely, one of them I've got is dealing with the case this way. The first one I came across in front of Mrs. Justice Judd. And it's proceeded on this part 25. We've got all our part 25s in. In fact, we've got all our part 25s in. And then lo and behold, one of the parents, I'm not a parent, says, oh, but now we need the post-mortem reports. And it's going to be quite interesting to see. I was discussing it with one of my opponents this morning, saying, well, I thought the deal was we did the part 25, so we don't have to have the post-mortem, because we all know that what Professor Mangum's going to come along and say is, it was worse, or I found this extra fracture, and you've got your part 25, you've got your Dr. Ward, you've got your radiologist, you've got it there, it's ready to go. It's listed in a couple of weeks' time, or 6 weeks' time, for a 4-week hearing. If we then go back to the pre-Re-G, well, what's the point in that? So that's quite interesting for me that it's kind of come full circle. Yeah. And the other one that I'm dealing with, we're just dealing with the part 25s, and it's happening as if it's just happening. It's just happening as if it was a baby who was alive who'd had a head injury. So it's working. I think it's working. I think we've got to time for questions. I can see one on our screen, Zoe, which says, what's the biggest change in finding of facts hearings as far as you're concerned? Do you want to have a go at that, or shall I? I think we've all just answered that, haven't we?
I think we have. You go with that one.
Okay. I think it's Re-G for the reason we've given. For the last 100 years, I am that old, we've been dealing with these cases on the basis that we have to wait. There is no alternative. You all know that's an acronym, Tina, there is no alternative, we know that. But we've all been saying, oh, well, we can't do anything because we haven't got Mangum's report, and we haven't got, Delaney's report, and we haven't got this and that and the other, but we can. And I think that's going to make a huge difference to the pragmatic approach, the overriding objective, because they'll be dealt with more quickly. And I'm really hoping Mrs. Justice Judd, Frances Judd, at the PTR next week says, no, we don't need the post-mortem report because of Re-G, and have a look. Why do we want the post-mortem report? What's that going to give us? It will give us something, we know that. But I think, to my mind, the biggest change in finding of fact cases has been Re-G, and the alternative, much more sensible, very, very Andrew McFarlane, in my view, pragmatic approach, which I approve of.
And I think when you tie all of what we've discussed this evening together, it really is focusing in on, isn't it? What do we need to be able to make a decision? What do we need for threshold? What do we need for care planning? It's narrowing the issues all of the time and not trying to overcomplicate things with what we've done before. It's trying to be proactive, trying to be progressive, knowing the strains that the family court are under, but always going back to the overriding objective and the principles of justice and fairness.
There's another question here, Zoe, which is what could we do better, and what could we do as barristers and solicitors to make sure that the judge is helped in reaching the right decision?
I think that I can answer that one. We go back to what we've already said. It really is about preparation, thinking about the case before the hearing. I think we often find, this isn't necessarily strictly to do with fact-finding hearings, but evidence more generally, solicitors know when you need police disclosure, you know when you need certain pieces of evidence, make those directions, make those applications beforehand. You can use the police protocol, but in preparation for your hearing, really think about that question of necessity again. What is this going to give the court to assist with the decision at the end of the day in the care plan? So that means having a really good detailed position statement, a really good detailed skeleton argument where appropriate, citing the case law, citing the principles that we've discussed today, spell it out for the judge, make it easy for the judge. Do you have anything that you would add to that, Tina?
I think I would have it a big headline banner, either at the top or the bottom. This piece of information X, the answer to the question I'm asking you to give us a finding of fact for, is required to determine the welfare stage. So did Tina Cook sexually abuse little Johnny? Is necessary for us to determine whether Tina Cook can have care of Johnny. So I think my headline banner now would be on all of them. What was the phrase I said to you earlier? Magnetic, forgotten my own phrase. It's not my phrase, it's Baker J's phrase. Magnetic factors. I would say the magnetic factor is X. And that's, you need this piece of information. And alternatively, if I'm arguing against it, I would say, but you don't need this piece of information to determine. I was just wondering, I know we're going to wrap this up, Zoe, but I was just wondering, would you say, because Baker J was quite hot on this in HW, if you were either for the local authority or the parent in that case, and you knew there were ABE interviews of the 12-year-old girl who'd made the allegation, would you have naturally said to the judge, you need to see those? Because I don't think I would.
No, I don't think I would. Not at a case management hearing. It's not something that's regularly done for a case management hearing, in my experience. And very difficult, I would imagine, in a 1 hour hearing to say to a judge, look, judge, you need to see this. I suppose that goes back to Baker LJ saying, look, you're not determining the evidence. But there's a bit of a conflict there, a bit of a tension, because he does say, but he hadn't seen the ABEs. And had he seen the ABEs, perhaps he would have, the judge would have granted the finding of fact. So I think maybe you take them to extracts of the transcript, if there was a transcript. No substitute, I know, for the ABEs, but that's an interesting conundrum, I think. Yeah, I agree, absolutely. All right, I think that's used up our half an hour. It's been lovely to talk to you about it. Can I just remind everybody before you sign off that the next webinar is on the 13th of April, 42 Bedford Row webinar. It is on the subject of the problem of memory in family fact findings, and Damien Wilbur-Carlton and Sharon Bactu are giving that. You can register on the website or phone Chambers.
but thank you very, very much.
I
Thanks.
should also say, just very quickly, in addition to that, I can see that there are a couple of questions that we haven't had time necessarily to cover. So we will have a look at those and we will address those in the reference materials that we're posting on Monday as well.
I missed.
So thank you, everybody. Good evening.
Thank you.
Bye-bye.